Reverse incorporation means that equal protection rights apply to the federal government through the Fifth Amendment's Due Process Clause. This issue arose in the Brown v. Board of Education case. That litigation actually was a consolidation of cases from a number of different places: Kansas, Virginia, South Carolina, Delaware, but also the District of Columbia. It included a lawsuit challenging racial segregation of the public schools in the District of Columbia. And that raised a tricky little problem, because the District of Columbia is not a state. It's a special federal district that is the nation's capital. And why does that matter? Why does it matter if the District of Columbia is a special federal district rather than a state? It's a problem because the 14th Amendment only applies to the states and to the local governments, like cities and counties, that are subdivisions or parts of the state. The 14th Amendment does not apply to the federal government. And this is apparent in the text of the 14th Amendment. It says no state shall do certain things. And so in the Brown case, the Supreme Court was deciding that racial segregation violates the right to equal protection, and that right is in the 14th Amendment. So at that point, they've struck down segregation in Kansas and Virginia and the other states. But what do they do about the District of Columbia? There's no equal protection clause in the Constitution that covers the District of Columbia or the rest of the federal government. So there's this dilemma. And perhaps one solution would be simply to say, I guess racial segregation is still allowed in the District of Columbia. There's no equal protection clause that applies to the federal government, so there's no constitutional violation there. But that just seemed like a ridiculous result. How could it be that the Supreme Court would get rid of racial segregation throughout the country in all the states, but not for the federal government and not for the District of Columbia? What a terribly odd thing it would be if the one place in the country where you could still have racial segregation was the nation's capital. That would be really embarrassing. And so the Supreme Court came up with a way to get around this little anomaly. They declared that the right to equal protection of the laws is not merely a part of the 14th Amendment. Instead, it's also something that is protected by the Due Process Clause of the Fifth Amendment. They said that getting equal protection of the laws is part of what it means to get due process of law. And so the Fifth Amendment prohibits racial segregation, and the Fifth Amendment applies to the federal government. And so that means you can't have segregation that is imposed by the federal government, including the District of Columbia. This conclusion that equal protection is part of the Fifth Amendment's Due Process Clause became known as reverse incorporation. And you can probably imagine why it's called that. We learned about things being incorporated from the Bill of Rights into the 14th Amendment, and here it's going in the reverse direction. We've got something in the 14th Amendment being incorporated into the Fifth Amendment. So that was a very clever way of achieving a situation where the same constitutional requirements apply to all levels of government. Every government must provide equal protection. The federal government must do it under the Fifth Amendment, and the state and local governments must do it under the 14th Amendment. There are a number of things that are a bit odd about this, perhaps even illogical. With the regular form of incorporation, it sort of makes sense from a timing perspective. You could say that when they wrote the 14th Amendment in the late 1860s, they were intending to incorporate the Bill of Rights, which was something that already existed. In other words, they were referring to it and making those rights apply through the 14th Amendment. It's a little harder to imagine how reverse incorporation could be plausible in that sense. Reverse incorporation is suggesting that when they adopted the Fifth Amendment back in 1791, they were intending for it to incorporate the Equal Protection Clause, which wasn't written until about 75 years later. So were they seeing the future? No, of course not. But there's that little bit of chronological problem there with reverse incorporation. Another odd little thing about it is that, again, notice that one of the premises of reverse incorporation is that a due process clause implicitly includes a right to equal protection. If you're entitled to due process, receiving equal protection is one part of it. But if that's true, then why did the framers of the 14th Amendment include both a due process clause and an equal protection clause in the 14th Amendment? Wasn't that redundant if due process by itself includes equal protection? The truth is that the Supreme Court didn't really care about these sorts of details. They didn't care if reverse incorporation might be a bit illogical in some ways or hard to justify from a historical standpoint. They simply wanted to have the same major constitutional rights apply to all levels of government, and they wanted to get rid of racial segregation in the District of Columbia or any other racial segregation done by the federal government. It's sort of like how the Supreme Court wound up using the selective incorporation approach to the incorporation of rights from the Bill of Rights into the 14th Amendment. Selective incorporation wasn't necessarily the most theoretically coherent approach or the most historically justifiable, but it was a good practical way of getting the job done and doing what they wanted to do. And so we wind up with a situation where the right to equal protection is protected by the Fifth Amendment for the federal government and its actions to the exact same extent as equal protection is protected by the 14th Amendment for state and local government actions. And as a result, everything we learned about equal protection is all true for all levels of government, federal, state, and local. The right is parallel whether it's under the Fifth Amendment or the 14th Amendment, and we don't have to worry about different levels of equal protection applying to different types of governments under different constitutional provisions.